Welcome to Landmark Chambers Property Law Nuts and Bolts Part 1 Mortgage Possession Proceedings Seminar. We're delighted to see so many of you joining the session today in person and online, and hope that you'll find the presentations and discussion to be useful and informative. You'll be hearing three presentations today. The first from Ed. Ed is in the final weeks of pupillage here at Landmark and will be joining us as a tenant on the 1st of October. He's already building a broad practice across Chambers' main areas of property, planning and public law. During his pupillage, he was supervised by Justin Bates and Jonathan Wills, amongst others, gaining experience across a range of residential landlord and tenant and real property issues, and has already been on his feet in cases in the County Court, the Magistrates Court and specialist tribunals. He's also recently joined the editorial team of the Encyclopedia of Housing Law and Practice, published by Sweet and Maxwell. Evie has a practice that's focused on property litigation, whilst also including a broader chancery practice, covering a broad range of residential and commercial property cases. Her recent mortgage work includes acting for a bank in relation to a number of mortgage possession proceedings, including a number of forthcoming claims involving undue influence, allegations, and issues about subrogation and equitable charges, alongside a broader practice covering landlord and tenant, leasehold enfranchisement, easements, trusts, and cases involving security interests. Brooke is a property practitioner with a wide range of experience in commercial, residential, and real estate matters. She's recently been involved in a high-value mortgage possession claim involving a property estimated to be worth around 75 million. And a highlight of her years so far was winning in the Supreme Court, led by Simon Allinson, in Aviva Investors Ground Rent GP Limited against Williams, which was obviously a hugely important decision for the residential leasehold sector. And she's also a co-author of the invaluable On Your Feet, a practical guide to civil advocacy. So without more ado, if I could hand over to Ed for the first presentation.
Afternoon, everyone. I'm very much the warm-up act for today. So what I'm going to do is give you a short overview of some key concepts and an introduction to some procedure, and hopefully that'll set us up nicely for Evie and Brooke to be able to provide more specific and practical tips on what's needed in conducting possession proceedings. So with that in mind, what we're going to cover, I'll start with some key principles and definitions. The main ones being what is a mortgage and what are the primary rights and remedies under a mortgage for a mortgage lender. Then we'll hone in on a specific right, which is the focus of our seminar today, which is the right to possession. And finally, I'll try not to bore you too much by talking about some procedure. So I'll be focusing on where proceeding claims are heard, the pre-action protocol and what requirements are needed, and then also what you need to include in a claim form and in a particulars of claim. So onto our first definition, what is a mortgage? So broadly, the essence of a mortgage transaction is that a charge is taken over the property as a security for the performance of an obligation. Now, the way most of us come to experience mortgages will be in the form of a legal charge over a property as a security for repayment of a loan which facilitated that property's purchase, or a legal charge over property securing business lending. Now, if like me, you still struggle to remember what exactly we're referring to when we refer to a mortgagee and a mortgagor, rest assured, and I think my co-host today, will all be referring to the much friendlier terms of lender and borrower. But just so you have it for reference, a mortgagee is a lender and a mortgagor is a borrower. I think that's right. Finally, for a mortgage to be a legal mortgage, it needs to be a charge created by deed. It needs to be expressed to be by way of legal mortgage, and it needs to be registered. But note, the actual phrase by way of legal mortgage does not need to appear on the deed itself. Now, if the loan is not satisfied in accordance with the terms of the agreement that created the mortgage, then the lender has a number of rights and remedies available to them. I haven't included all of them, but some of the main ones are here on the slide. So the first is selling the property to realise the security. The second would be to appoint a receiver over the mortgage property or part of it. The third is the focus for us today, which is entering into or seeking an order for possession. The lender may want to bring an action against the borrower under the covenant. And then finally, I've also included seeking foreclosure, but that's an equitable right that's quite rare in practice. Now, a lender's decision as to which of these rights they wish to enforce and by which route will be influenced to a large extent by the size of the debt, the value of the security itself, and perhaps even the particular financial circumstances of the borrower, if they know that information. On the right to possession, it's important to bear in mind that a lender can enter into possession without actually taking the keys of the property. So the lender, for example, may exercise their right of possession by giving notice to the borrower's tenant, to pay rent directly to the lender in possession. When does that right actually arise? Well, in principle, the lender has an immediate right to commence an action for possession of the property as soon as the mortgage deed is executed, unless there's an agreement to the contrary. You may have heard the quite famous phrase that a lender may go into possession as soon as the ink is dry on the mortgage. That's from the 1957 case of Four Maids Limited and Dudley Marshall. Now, despite this, it doesn't actually mean that the lender can go and exercise its right to take possession for any purpose that it so chooses. The right to take possession must be exercised in good faith, and possession should only be sought to secure satisfaction of the debt that is secured by the mortgage. As well as that, there are some specific qualifications and restrictions on the right to take possession. The first of these is that the mortgage deed will commonly provide that the lender will not exercise their right to seek possession, provided that the borrower maintains the repayments due under the mortgage. So if seeking possession in such a case, the lender will need to demonstrate that the conditions for seeking possession in the event of default have actually been met, and also that any notices or other procedures provided for under the agreement have also been complied with. Where a mortgage is a regulated mortgage or a regulated agreement under the Consumer Credit Act, then a right to possession is only enforceable pursuant to a court order. There are other qualifications and restrictions. So, for example, if there's a receiver already appointed at the request of a third party, the lender can only enforce their right to possession if that is provided for in the court order that appointed the receiver in the first place. I'll also particularly highlight here the point on court's discretion. Now, this is something I believe Evie will cover in a bit more detail, but it's important to highlight that the court has discretion to grant a stay of proceedings relating to residential property under Section 36 of the Administration of Justice Act of 1970. Finally, by taking possession, the lender in effect becomes the manager of the property, which comes with specific duties and liabilities, and this may inhibit the willingness of the exercise of the right of possession. These include the liability to account strictly to the borrower, liabilities in negligence resulting in any damage to the property, liability for repairs, and generally liability under any covenants contained in the tenancy agreement by which the borrower might be bound. So moving on to procedure. The highlight point here is that, save in exceptional circumstances, claims for possession should be brought in the county court. Proceedings to enforce a regulated agreement must be brought in the county court as well. Exceptional circumstances arise where there are complicated disputes of fact or points of general importance. But note that this does not normally include the value of the property or the amount of any financial claim, although these may be of wider relevance. You should also know that if a claimant starts their claim in the High Court and the court decides it should have actually been started in the county court, the court will either strike out the claim or transfer it on its own initiative. You need to be aware that this may result in sanctions. Not only will there be delay, the court will often disallow the costs of starting a claim in the High Court, and the fee of any transfer is to be taken into account as well. But where a claim relates to residential mortgages, the lender needs to take care to ensure that they've complied with the pre-action protocol. This protocol is intended to encourage mortgage lenders and borrowers to engage with each other as soon as the borrower starts falling into arrears, with a view of avoiding possession proceedings altogether. Now, the protocol applies to very specific types of mortgages, and you'll see the 3 bullet points highlighted here. So the first is the first charge residential mortgages and home purchase plans regulated by the FSA. The second is the second charge mortgages over residential property and other secured loans under the Consumer Credit Act. And finally, unregulated residential mortgages. Note that the protocol expressly states that it does not apply to buy-to-let mortgages. Paragraphs 5.1 to 5.7 of the pre-action protocol sets out the steps which should be taken by both parties as soon as the borrower starts falling into arrears. I won't read all of them out as they're there for you on the slide. In particular, I'll highlight the final 2 points, which are about the need to provide the borrower with required regulatory information or the National Homelessness Advice Service booklet, as well as providing advice on making early contact with the local authority housing department, or where necessary, referring them to appropriate sources of legal advice. I'll also ask you to note that the protocol also requires that if the lender is aware that the borrower may have difficulties, for example, in reading or understanding the information being provided, the lender should also take reasonable steps to ensure that the information is provided in a way that the borrower can actually understand. Now, paragraph 6.1 and 6.2 provide circumstances in which a lender should consider not starting a claim for possession. These are chiefly where the borrower has submitted a claim to an insurer under a payment protection policy, or if they can demonstrate they'll market the property appropriately. The protocol emphasizes that starting a possession claim should be a last resort. So alternative dispute resolution is positively encouraged. And paragraph 7.1 provides some examples. For example, extending the term or changing the type of the mortgage, deferring payment of the interest due, or capitalizing the arrears. If the borrower makes a proposal for payment or a reasonable request to change the date of a regular payment or the method by which payments are made, and the lender does not agree to such a proposal or request, then the lender must still give the borrower written reasons within a reasonable time. Where the lender decides not to postpone the start of proceedings, it should inform the borrower of the reasons for the decision at least 5 business days before starting them. And then where proceedings are issued, the lender must bring 2 completed copies of Form N123 to the court. This is a checklist requiring the lender to identify how it has in the previous 3 months complied with the protocol. So what's needed for the claim itself? Well, the claim form is on Form N5 and the particulars of claim on Form N120, and both of these must be filed and served together. Now, the particulars of claim may be varied if required in the particular circumstances of the case, but you'll still need to contain the information which is prescribed in the civil procedure rules, particularly in 55A, 55(4). When dealing with residential property, then the particulars also needs to give details as to whether a Class F land charge has been registered, a notice under the Matrimonial Homes Act has been registered, or a notice under the Family Law Act of 1996 has been registered. It also needs to detail the state of the mortgage account, including solicitors' costs and administration charges to redeem the mortgage. In the case of a regulated consumer agreement, the total amount outstanding also needs to be provided. Where the claim is based on mortgage arrears, there are further matters that must be set out in the particulars of claim. These include a schedule containing the arrears and payments made to date, any information relevant to the defendant's circumstances, in particular whether they receive Social Security payments or whether Social Security payments are being made on their behalf directly to the claimant. All persons who are known to be claiming an independent right to occupy should be joined as defendants. Generally, it's not necessary to claim interests and costs, as the lender usually has a contractual entitlement to the same under the terms of the mortgage. Finally, there are specific notice requirements that need to be complied with. So within 5 days after receiving notification of the hearing date, the lender must send a notice to the property addressed to the tenant or occupiers, containing the information prescribed in 55.10.3 and 3A of the CPR. At the hearing, the lender must produce a copy of that notice and evidence that he has in fact served it. Now, it's vital that such a notice is served, as it may be the only way that a potential defendant to the claim, who might have a better right to possession than the lender, will be aware that possession of the premises is being sought. There's evidence that such a notice has not been served. It's difficult to see how the claim can proceed fairly, even if the borrower does not appear to have an actual defence to the claim. Thank you for listening. Evie will now cover key defences.
Thanks, Ed. As Ed said, I'm going to cover off some of the areas in which a borrower might think to defend a mortgage possession claim. On the screen, I have 4 headings. These are not exhaustive, and there are likely to be many other contractual, equitable, statutory defences that an inventive lawyer or borrower could come up with. But at high level, I'm going to try and highlight some of the main options on the menu for a defendant. For starters, you have contractual defences. As Ed highlighted, ideas around whether the sums have become due under the charge. Then coming on to the second point on my slide, equitable defences is what I've called this. Ideas like undue influence, mistake, misrepresentation. Then third, time to pay, which is section 36 of the Administration of Justice Act. And last, what about tenants or family members? Ed has already covered this, so I don't propose to go through it in any more detail. But the sort of premise for what I'm about to say is that I'm focusing on the lender's right to recover possession of the property that is often coupled with a claim by the lender on the personal obligation of the borrower to pay the sums that are secured by the charge. The lender's power, if they're a legal charge holder, to appoint a receiver or sell do not require court orders. That's different if the lender has an equitable charge, which would require a court order for sale or an order appointing a receiver. But in the case of a legal mortgage, the lender's powers to sell or appoint a receiver come from the Law of Property Act or under the charge. Whereas a lender, if they want to sell with vacant possession, will need an order for sale. An order for possession. So, turning first to contractual defences, on this slide, I've limited myself to what are the lender's rights under the charge. I won't go into this, but it's also worth thinking about the formalities that Ed mentioned. For example, has the mortgage been made by deed? Was it witnessed? Recently, I had a trial where one of the borrowers said that her signature hadn't been witnessed by the person who had signed the document. And that then gave rise to a response from us, which was, well, who cares? It's an equitable charge. That required some amendment of the particulars because for an equitable charge, we needed to seek an order under section 14 of Tolata to sell the property. But the response from the borrower was, well, if you've got an equitable charge, you haven't complied with section 2 of the Law of Property Miscellaneous Provisions Act, that the lender as well as the borrower sign the document. Now, I think that is probably answered entirely by a Court of Appeal case called Roller, Team and Riley. But there is some murkiness in this area because of some conflicting High Court authorities. So it's worth thinking about this if the deed isn't properly compliant with the requirements, or perhaps that there are some other formalities issues. And another thing to perhaps think about is whether there has been an assignment of the mortgage and the requirements of Section 136 of the Law of Property Act have been complied with. I'll come on in a minute to the timing of claims, but moving back very briefly to obligations under the charge itself. As Ed said, the right to possession is classically described as arising before the ink is dry, and Ed referred us all to the Four Maids case. Importantly, as Ed said, in that case, Mr. Justice Harman said that arises unless there is something in the contract expressly or by implication which changes the position. So read the charge carefully. Are there any contractual preconditions? Is the loan repayable in instalments? If so, it's very likely, very common that the mortgage restricts the entitlement to possession until there is some default. And even if not, that term may be implied if not express. Lots of cases on that point. So worth looking at that carefully. Also, as Ed said, does a demand have to be made before the right is exercisable? That may particularly be the case if you've got a slightly unusual situation where monies are loaned to borrower, but then another person offers security over a property and maybe stands up as surety. In that situation, it's very common for the requirement to pay and the entitlement to seek possession to arise only on demand. And then you have to think about when post-demand the entitlement has crystallised. Is there a reasonable period within which payment must be made? Less common still, but also possible defences are things like jurisdiction clauses and perhaps coupled with that choice of law clauses. And last, as I say on the slide, it's important to remember that there might be different defences to different parts of the claim. For example, it might be that you have a counterclaim to the money judgment, but that does not completely answer the right to possession. And we'll touch on this further, but that intersects with practically how things might work when your possession claim is heard, in that it is not uncommon for the court to adjourn the money claim side of things, but still give the borrower, the lender, possession of the property. Very briefly, just touching on limitation, any loan that isn't by deed will be subject to the 6-year limitation period for payment of sums due under it. But if you look to Section 12 of the Limitation Act, that provides a 12-year period for recovering any principal sum of money secured by a mortgage or other charge on property or the proceeds of sale of land. That does not extend the length of time for bringing an action for arrears of interest, which is limited to 6 years by Section 12, subsection 5. But that's also not the same as the time limit for bringing an action to recover land. And most of us will be dealing with registered land. So that's Section 96, subsection 1 of the Land Registration Act, which says that there's no limitation period for registered land. Unregistered land is different. I'm just going to refer you briefly to that. It's a slightly complicated picture, but it's worth looking at sections 15 and 17 of the Limitation Act. Moving on now to some of the more juicy defences, the things that give rise to the factual disputes and some of the more interesting legal arguments. Undue influence. On this slide, I've got Royal Bank of Scotland and Ettridge, which is the famous case on this. Undue influence arguments are quite common, I think particularly so where you've got jointly owned property owned by a couple in a romantic partnership. Last year, I had a trial where husband and wife had granted a charge to a lender to secure a loan which was being taken out to remortgage the property. The wife said that her husband had always been the dominant character in their relationship. And she was now separated from him, but previously she had always bowed down to his pressure. When my particular lender had granted the charge, she had said that she'd gone to her husband's offices where she was met with her husband and a bank manager. And through the course of a very short meeting, she was presented with some documents and told to sign. And when she asked questions, she was told in Arabic, "Don't worry about it, just sign it." Her case was there was presumed undue influence and the bank was put on inquiry because of the nature of the mortgage. So what that type of case illustrates is a sort of undue influence defence that you see run. You don't very often see a two-party situation. Bank puts pressure on borrower. It's much more common that you've got a three-party situation. One of the borrowers is putting pressure on another borrower, and because of the circumstances of the case, the bank is put on inquiry. What then are the precise requirements for undue influence, and when will a lender be stung by an undue influence claim? Well, firstly, whether the transaction was brought about by the exercise of undue influence is a question of fact, the burden being on the person who claims to have been wronged. And the burden of proof can either be discharged by establishing actual undue influence, i.e. the complainant shows that they entered into the relevant transaction because of some improper pressure or coercion that deprived them of their free will, or on the other hand, presumed undue influence. Now, for presumed undue influence, there are two stages. The first stage is either the relationship is one that is in a special class, and we don't tend to get very many of that, or more commonly, it's one where, on the specific facts, one party reposes trust and confidence in the other one. And then secondly, the nature of the transaction is such that it calls for explanation, i.e. it wouldn't have been entered into other than because undue influence had been used to procure it. Now, if both of those two conditions are met, the burden will shift from the complainant, and in lots of the cases, it's wife complaining about husband's conduct, but there's obviously no reason that it has to be like that. It could be any situation, and the court will presume that the transaction was obtained by way of undue influence unless the influencer or the lender can show otherwise. The question is, for displacing that or showing undue influence, had the alleged influencer failed to discharge the obligation of candour and fairness owed to the complainant who was looking to the influencer to make the major financial decisions. So in my case, what the wife needed to show was both that she reposed trust and confidence in her husband and that the transaction was one that called for explanation. If you meet that step, then you go on to stage two, which is that the lender won't be adversely affected by the undue influence unless it either had actual knowledge of it or constructive notice. And in the second case, the lender failed to take the steps to remove the constructive notice. Now, the classic case for constructive notice, and a number of the decided cases are this, where a wife gives a guarantee or provides security over her property for business lending for her husband. And the rationale, which is important to bear in mind for the more broader application of it, is the transaction is not on its face to the financial advantage of the wife, and there is a substantial risk in the transaction of that kind that the husband committed a legal or equitable wrong that entitled her to set aside the transaction. So on one side of the line, money being advanced to one person solely, where it's secured against jointly owned property, where it's not manifestly for their joint advantages. Totally different situation where it's being advanced for joint purposes. And the lender is critically not obliged to discover whether the complainant has been wronged. Things like remortgages not ordinarily going to arouse suspicion. But the easiest way for the lender to get around this is what's on the slide at number 3, taking steps to remove the constructive notice. And that has now been very clearly set out in Ettridge as a result of Ettridge. And at high level, there are 3 steps. The first step is lenders should check directly with the complainant the name of the solicitor they want to use, and say that it will require written confirmation from the solicitor to the effect that the solicitor has fully explained the transaction. As part of that, the lender has to say to the complainant that the purpose is to eliminate a potential dispute down the line, so that the complainant is bound. The solicitor has to advise separately, but it doesn't need to be a different solicitor to that of the potential influencer, and indeed that of the bank or lender. Then step 2, the lender has to provide that solicitor with the relevant information to advise, and that depends on all the circumstances of the case. And then last, the lender has to obtain from the solicitor written confirmation of compliance with those steps. And those are steps that are applicable to transactions that occurred after the Ettridge case, i.e. 2001. In relation to earlier transactions, the lender generally will be regarded as having discharged the obligations if a solicitor who was acting for the complainant gave the lender confirmation to the effect that they had brought home the risks that were being run by entering into the transaction. Imagining a world where undue influence can be proved by one of the borrowers, what then happens? The transaction is voidable, not void, so it can be set aside. It's a discretionary jurisdiction. But generally, in order to do so, the person who has received benefits under a contract has to make good those benefits. In the usual 3-party case, what happens is any joint tenancy of the property is severed, and an equitable charge is created over the other borrower's interest. So in that situation, a possession order can still be obtained under section 14 of Tolata, and also an order for sale would be necessary there. It's also worth thinking about the final bullet point on this slide, which is subrogation. If the sums that the lender advanced were used to pay off an earlier charge, there is the potential for the lender to stand in the shoes of the earlier charge holder. That is subject to compliance with the usual rules for unjust enrichment. But if you can make out those requirements, what you're entitled to do is be paid up to the amount of the debt which was discharged by your advance. So it's critical what was paid off, and it's also critical to look at what the terms for interest are under the previous charge. Very briefly, some other ideas for potential defences that a borrower might run. First, forgery, i.e. my signature was not my own. But in that situation, the borrower would still need to satisfy the requirements in Schedule 4 to the Land Registration Act 2002 if the mortgage were registered. Misrepresentation, i.e. the person was induced to enter into the transaction as a result of false representations. Again, it's the transaction is voidable, not void. Mistake, I put mutual mistake on the slide rather than unilateral, but unilateral also exists as a possibility. In both situations, the remedy is rectification, not setting aside. So it might be that you can change some of the terms which are not beneficial to you, but you're not going to not be bound by the transaction. And then very briefly, I don't propose to go into them in any detail, but it's worth looking at the possibility that certain transactions can be set aside under the Insolvency Act if the borrower is insolvent. And there are also wide-ranging powers under the Consumer Credit Act 1974 if it applies, and that's a very big if. It's a very complex piece of legislation, and it only applies to, I'm not really going to go any further than to say it only applies to certain transactions, but it is worth looking at if you are a borrower, especially the provisions in section 140A and 140B, because 140B gives the court really very wide-ranging powers to effectively rewrite the bargain in certain circumstances. And then moving on to section 36 of the Administration of Justice Act 1970. This is the power for the court to provide time for payment of the sums due under the mortgage, whether by an adjournment or suspension. And it's worth remembering that there is supplementary provision in section 8 of the Administration of Justice Act 1973. Lots of mortgages will provide that if a borrower defaults on an instalment, that will accelerate payment of the whole of the principal. So miss one, have to pay all. And what section 8 says is that for the purposes of section 36, the sums due can be considered to just be the arrears as at the point where this is being considered rather than acceleration of the whole of the principal. But more broadly, thinking about how will these provisions be exercised, and there are in my mind, two main times when they will kick in. One is the borrower is proposing to pay the arrears that have arisen. Now, in the absence of something unusual, a reasonable time to pay is the remaining term of the loan. So if you've got a 20-year loan and a borrower misses a payment in year 2, you're thinking about the remaining 18 years. That does not mean if there's no unexpired term, the provision can't be used, but the borrower is going to get a lot less indulgence. The question is then, can the borrower pay off the arrears plus the sums over that period, i.e. the remaining term over the remaining term? So a very sort of crude mathematical approach is generally used. You've got what will be the current monthly instalment figure, what are the arrears over the remaining term, and that's often called the Norgan figure after the leading case on this, which is Cheltenham and Gloucester and Norgan. And then the question is, what is manageable by reference to the borrower's evidence of ability to pay now and in the future? So relevant considerations include, why did the arrears accumulate? Is this a temporary issue? And if so, why so? And for how long will it last? Are there any other relevant contractual terms? What is the type of mortgage? Should the court disregard the acceleration provisions? Is it reasonable to expect the lender to wait to recover the arrears of the interest, or effectively extend the term if you've got a expired term loan? And is it reasonable to expect the lender to capitalise? So what is the equity position? Have you got sufficient security, bearing in mind the arrears and the interest? The other situation I imagine, or that it often comes up in, is where there's a sale of the property that's proposed. What a reasonable time to pay is very different there, because what you're not looking at is the term of the loan for the reasonable period. What is reasonable depends on all the circumstances. So you need to consider carefully what the evidence are of a prospect of the sale happening, what the time scale is, again, critically, what is the value of the security compared to the value of the debt. And that generally, that latter point is what trumps everything. Is the lender sufficiently secured? And another helpful thing to think about if you're acting for a borrower here, will the debtor agree to pay the interests and arrears accumulating pending the sale? If the sale is not going to discharge the debt, then unless there's another way for the entirety of the sum to be paid, the court isn't going to exercise its jurisdiction there. Very briefly and lastly, I've got a slide that says who are the proper defendants. It's a bit circular, this, because in part it turns on what remedies the lender is seeking. But in the simplest case where you've got a borrower in occupation and they're also personally liable under the covenant, that's a very obvious who is the natural defendant. I'm thinking more of cases where the property is occupied by somebody other than the borrower. If the borrower has a personal covenant to pay and you want to sue them, by all means, join them as defendant. But the question really is, if you're just wanting possession, do you need to join them? I would think probably not really. Who do you join? As Ed said, if they're lawfully occupying, you're going to have to include them. But what about where they're unauthorised tenants and you're not bound by them as the lender because the power of leasing is excluded or excluded without your prior consent? I do a lot of receiver work as well, and that can prove to be quite difficult for receivers in a way that it wouldn't be for a lender, because you wouldn't be bound by the tenancy. So that's also something worth thinking about if you're advising a lender. But in a situation where you've got an unauthorised tenant or someone in occupation, it seems to me open to the lender not to join those persons based on a very old case of Brighton and Shaw and Building Society and Hollingdale, which was pre-CPR, but in which the court said if there's a person whose interest does not bind the bank, they don't need to join them to a party to the proceedings. And there's subsequent authority in the landlord and tenant context called Re Wickham's Terrace, which takes that up. On the other hand, the safest course is really to join them, and that's sort of reiterated by a more recent High Court authority called Sparkasse and Coutts. And it's also consistent with what you're claiming because you're seeking possession from the person who's in possession. And especially where you have unauthorised tenants, it's worth thinking about this because of the Mortgage Repossession Protection of Tenants, etc. Act 2010, where unauthorised tenants can ask the court to postpone the date for delivering possession in certain circumstances. So really, you're probably getting out ahead of all of this. If you're suing someone who's not the borrower for possession, do you have to join the borrower? Well, not unless you're seeking relief from them. You are entitled to pursue any or all of your remedies concurrently against the debtor. So really, it's up to the lender there. So in short, lots of possible routes for a borrower to potentially defend a mortgage claim. Of course, whether they're open to the borrower depends on the specific facts. But how the borrower approaches those in the short term can be a sort of defence because it might buy them extra time. And I'm going to leave that there because that leads on naturally to Brooke, who's going to cover off practical hints and tips.
An excellent segue there by Evie. So my excellent colleagues have done all the hard work and talked to you about the actual law. I'm going to spend the next 15 minutes or so talking you through some of the practical things that you can do, whether you're acting for a borrower or whether you're acting for a lender, to try to get whatever remedy it is you seek, perhaps as quickly as possible if you're acting for the lender, or perhaps if you're acting for the borrower, to slow things down as much as possible. I should say before I begin, the first thing that you can possibly do to ensure that you're prepared in terms of mortgage possession work is to buy Jacqueline's book. I didn't tell her I was going to plug it. I have a copy myself. Jacqueline's got it in front of her. It's very slim. It goes into a bag very easily, but also covers all of the things that you might need if you're stuck or need practical advice on it. So before proceedings are issued, there are some things you can do to try to maximise your client's position as far as possible. If you're acting for a lender, the first thing to do is create a careful checklist and run through it very carefully to ensure that the right to enforce has actually arisen. You've heard from Evie about the various defences that are available. I try to, both when I'm acting for lenders and acting for borrowers, whether I'm acting in mortgage possessions or in rental possessions, try to create sort of checklists that can be used so that you can literally run through the types of things that arise and tick them off as you go once you've read through the papers and worked out what the position is. It might just be that your client needs to serve a notice, and that when you run through the charge, the conditions in which the rights to enforce arise, a notice needs to be sent. if that's not done, you've got a complete defence that a borrower can raise. So create yourself a checklist, run through all the documents, make sure you're happy that the proceedings are going to be good proceedings before you start. The next thing when you're acting for a lender is to comply with the pre-action protocol. Those of us in the room that are property litigators or litigators in general will know that the pre-action protocols in different scenarios are given more importance. In some cases, in other cases, judges couldn't care less whether you've complied or not. When you're dealing with mortgage possessions and you're dealing with people potentially being evicted from their homes, the courts do take them really, really quite seriously. If you get to a first possession hearing in a mortgage claim and you haven't, and your client hasn't complied with the pre-action protocol, in reality, you can expect an adjournment. It's really, really important. And demonstrating compliance is really just as important as doing it in the first place. Switching sides now, if you're acting for a borrower, there are things that you can do, particularly if you are instructed early enough on to try to help them out. In reality, this may well be a bit academic because often it is once the proceedings are issued that you actually are faced with dealing with these matters. But supposing in some lucky world you're given instructions or you're representing someone before mortgage possession proceedings have been issued, the key point is getting your client to take steps before those proceedings are issued. Getting early advice on the potential substantive defences that might come up if proceedings are issued, but also taking practical steps to try to head off those proceedings before they happen. For example, if they're in arrears, there are financial problems, and you know that bottom line is they're not going to have a defence, do you need to say to them at a very early stage, you need to look into refinancing options, you need to get this house on the market, all in advance of litigation actually starting. It may also be simply a case of writing to the lender and saying, look, there's been a temporary problem. My client's in a position where they can make a proposal to make payment to pay off the arrears over the next year, 2 years, 5 years, and getting the lender to agree to something that is realistic. Okay, proceedings have been issued. There's a hearing in the not too distant future. What can you do if you're acting for the lender to secure their remedy as soon as possible? In reality, a lender, normally their priority will be maximising the chances of a possession order at the first hearing. And the way to do that is to get all of your ducks in a row in advance so that that hearing can be as straightforward as possible. Simple points, back to basics. Has the claim been served properly? Those of you that deal with the county courts on a regular basis like I do may well realise that the county court can't often these days do the basic things like serve documents. I had a case last year, we all turned up to a possession hearing, no defendant, and the judge said to me, I'm sorry, I've seen the letter where your solicitors asked for the court to carry out service, but I've got all of the documents, all of the sealed copies of the claim in front of me, it's never been served. And that happens, unfortunately, all of the time. So if you are carrying out service, make sure you've done it properly, and make sure you've got evidence of service, but checking those points can be crucial. And unfortunately, don't trust that the county court is going to have done their job properly. The second point, and this is something that Ed touched on earlier, have you complied with 55.10.2? And this is a slightly, a provision that's peculiar to mortgage possessions, and that's the requirement to send notification of the date of the hearing to 3 categories of third party. And that needs to be done within 5 days of notice of the hearing date, essentially so that you can give any tenant or occupier or the housing department of the local authority and any other registered proprietor of a registered charge notice of the proceedings, notice of the hearing date, such that if they want to attend that hearing or they want to be joined as a party, they're on notice of it. It's a procedural requirement, but I can tell you that quite a few of the cases that I've been instructed on, it's been missed. It's just something that someone's missed, and you get instructed a few days before and that hasn't been done. And again, it's the type of thing that a district judge in a busy list might say, well, you can't prove compliance with 55.10.2. I'm sorry, I'm adjourning this off. So doing it is crucial, and being able to prove you've done it is equally as important. Moving back to putting my borrower's hat on, in reality, unless you are in the fortunate case of having a substantive defence, i.e. something like undue influence, where there's actually a substantive defence to the claim, most of the time what you're trying to do is buy your client time. And there are various things you can do in that period between service of the claim on your client and that first hearing to try to put them in a better position. Investigate the potential defences. You're going to have an involved conference with your client where you run through the types of questions that might get from your client any issues around whether the documents were formally executed in the right way, whether there was any undue influence or pressure on them that gave rise to the transaction, or any of the other things that could potentially give rise to a substantive defence. If you're then in a position where actually there isn't going to be a substantive defence, it may well be next advising them on taking practical steps to try to investigate alternative funding, put the property on the market and that kind of thing. If you can persuade your client to do those things and they do take those steps, then you may well be in a position where you can actually write to the lender's solicitors and say, look, my client has taken these steps. We know there's a hearing listed. Can we agree to stay the proceedings for 3 months to give my client an opportunity to refinance or to sell or whatever it might be? Most of the time, a lender will not do that unless there are concrete steps that you can show that your client has taken. Preparation for the hearing. Back to being a lender for a moment. As I say, the key thing that you will need to do is present the case as simply and straightforwardly as possible. And I've put on the slide a point about hearing bundles, and this is perhaps a personal pet peeve. During COVID, those of you that dealt with possession matters when there was the temporary practice direction may well recall that there was a requirement to provide a hearing bundle. Now, generally speaking, when you're doing a possession matter, there isn't a requirement to provide a hearing bundle. And I think post that practice direction, which no longer applies, district judges started to get comfortable with the idea of actually having a hearing bundle in front of them that had all the documents. So I think judges since then have become less tolerant of an expectation that they are just looking at the documents on the file. And I think money is very well spent by a lender or a person seeking possession if they actually send a proper hearing bundle in advance to court. It means that all of the documents are in one place. It means that everybody hopefully will be following on from the same pagination, which for counsel is incredibly helpful. But also in a scenario where the court has lost the documents, has given the judge the wrong file, again, you've maximised the chances of actually making your hearing effective. I was in Stratford Housing Centre for a possession matter at some point in the last year, and went in front of the district judge, who said to me, well, have you got a hearing bundle? And I said, I have actually, I've got a spare copy. The judge didn't have a single file for the entirety of her list. Because I don't know if you know, Clerkenwell and Stratford Housing Centre are part of the same court. Clerkenwell are supposed to ship over all of the files for the Stratford Housing Centre judges to do their list, and then they're supposed to go back to Clerkenwell. That day, none of the files had been sent over. So the district judge was just hoping that the parties would turn up with the relevant documents so that the hearing could be effective. An entire day's list. So, moral of the story, get a beautiful hearing bundle, put all of the key documents in it, and send it into court in the hope that they don't lose it before the hearing, because that might be the difference between an ineffective hearing and an effective hearing where your client gets what they want. If you're acting for the borrower, that period in advance of the hearing is crucial. If you've investigated defences and you've come up with a substantive defence, clearly you ought to put that in a properly pleaded defence in advance of the hearing. Whilst it is often overlooked, the usual 14-day rule does apply. People overlook it, it's forgotten about because we have the first hearing, and usually there's not much of a consequence if you don't file and serve within 14 days. But what's really important is to get it in far enough in advance that you might be able to agree an adjournment or a stay of the proceedings. So if your client's got a substantive defence, get that in as soon as possible. There is a form, but in reality, if you're putting forward what I've described as a substantive defence, you're going to need to do a bespoke defence that sets out your client's position more fully. Also, just from a practical perspective, if you can wave around a 10-page, 15-page defence, in reality, that is going to be a much better way of getting you adjournment than if you've just got the normal form. Even if you're not in a situation where you've got a substantive defence, and if you are just arguing for time, your client ought to be putting together, or you might need to put together for your client, a witness statement that needs to be served at least 2 clear days before the hearing, setting out where they're at, explaining what the reason for the arrears or the default is, setting out what steps they've taken to address that concern. If it's a temporary problem, i.e. they lost their job, didn't pay their mortgage for 3 months, but they're now re-employed, evidence about that, and supporting documentation. If they're proposing that they can make payment over a certain period of time, again, evidence supporting how they're going to do that. Evidence about what equity there is in the property, an indication of how much it's worth. Evidence about how they're exploring refinancing options, or a family member is going to help them out. All of that stuff needs to be in a witness statement, and the quality of that evidence is really important. A poorly drafted witness statement can really be the difference between your client getting enough time to sort things out and not. As I say, at least 2 days, clear days in advance is the rule. A witness statement late is better than no witness statement at all. And if it has to go in at 11 o'clock the night before because your client has only instructed you that day, so be it. Ensure that counsel brings along 3 copies to the hearing so that everybody's got it and the judge can at least see, look, this is what's happening, this is the situation, and this is the basis upon which either an adjournment might be obtained or at least a long time order, giving your client plenty of time to do what is needed. If you manage to do either of those things with sufficient time, it might mean you do manage to agree an adjournment or a stay with the lender. If they're given information that says, actually, there is a realistic chance they're going to pay this off, or actually there is a sale impending, you manage to put it on the market and you've got a purchaser, most lenders, properly advised, will think, well, actually, if that's going to get us what we want, if our security, if we're going to get our money, then actually we're happy with that. Let's all agree an adjournment of the proceedings. At the hearing itself, I've kind of mentioned it already, making things seem really straightforward is key. Having your hearing bundle, any documents you're going to hand up, make sure they're in a clear format. Make sure you bring along copies of the pre-action protocol checklist, copies of the hearing notice that I mentioned earlier. If for some reason if you're seeking money judgment, you might need, for example, an up-to-date redemption figure. Can it be in a clear format? The amount of times I'm given documents, whether they be arrears schedules, redemption, and you have no idea really what they say. Someone somewhere knows what it means, but you don't. And when the judge says to you, how exactly do we get to that figure? How does the interest work? If you can't explain it, answer is an adjournment. And it's possible sometimes you might get your possession order and the money judgment might be adjourned off to another day, but your client doesn't want that. So if you can say to them in advance, whatever document's going to give me, make sure they're clear. And if they're not clear, give me the explanation of how they work so that I can explain it to the judge. Borrower, obviously the opposite is true. When you walk into a 10-minute possession hearing acting for the borrower, you want to talk as slowly as you possibly can and explain why this is all far too complicated to be dealt with in a 10-minute hearing. I've put on the slides there the key test, which is the district judge asking, is the claim genuinely disputed on grounds that appear to be substantial? It's the same test for all possession hearings. And we've been recently told by the Court of Appeal that that's the same test for summary judgment. Remember what a high threshold that is. And if you've put forward a substantive defence, no judge should be granting a possession order. If there are disputes of fact, no judge should be granting a possession order. Obviously, if you're acting for the borrower and your potential arguments are pretty thin, it may be you have to take some procedural points. Have they failed to comply with the pre-action protocol? Are there some procedural defects that you can rely upon? In reality, you need to think about how realistic they are. Don't think, well, I've been instructed in this mortgage possession claim. We've been instructed for 3 weeks and we know they've not complied with the protocols. So we're just going to sit on it and hope that that gives us an adjournment of the hearing. When a borrower has got the benefit of legal advice, particularly in advance, those types of procedural arguments carry probably less weight, because there's time essentially for the solicitors write to the other side and say, you didn't do this thing, you ought to correct it, or you didn't do this thing, can we agree an adjournment? So be realistic about, you know, how useful those kind of arguments are going to be. One final point, and this is just a personal one from my perspective, I think it's really important for claims of this sort for the borrower to attend court. Firstly, really helpful in terms of getting instructions on the day. Things can arise during the hearing, before the hearing, where you might need direct instructions from the client. But also from a human perspective, judges don't like making possession orders, particularly where the person in the back of the room is the person that's going to be evicted from their home. So if you're acting for a borrower, one of the most powerful things you can do is ensure that they attend court. And that brings me to the end. I think we're going to now go through the Q&A, but thank you very much for listening, both everybody in the room and everybody at home.
I think with that, I'll start by opening the floor to those in the room. Are there any questions arising from any of the presentations, or tangentially linked to any of the presentations, or a burning question about mortgages that you might be able to assist with in the room?
In an undue influence claim, what would be the effect of a conviction for controlling and coercive behaviour? Would that be extremely helpful to you? Is it a slam dunk at that point to show undue influence in the event that, I know that that's unlikely to happen in the timescales because they're not going to marry up.
Yeah,
well,
it's going to be pretty compelling evidence, isn't it? Of I would have thought presumed undue influence, not necessarily actual, but it also is probably quite compelling evidence of that. I guess in most cases now, lenders have complied with the Ettridge. So if you're acting for a lender, you hope that you don't need to really touch on whether there's actual influence or whether it's presumed. You can get around that by Ettridge. I think you would really struggle, wouldn't you, if you were the bank cross-examining the person who'd been the victim of that. But ultimately, it's not. I think the rules on judgments from or decisions from Crown Court are that they aren't binding by way of facts. But I can't really see a county court judge finding otherwise. Can you?
And that's going to be the best
Evidence
you could possibly have.
And presumably leaving aside the actual conviction, the evidence which was led in that jurisdiction is going to be the same as what will be led in the county court, and will be pretty damning. Do you have one like that?
No, not at all. I've crossed over from being a senior Crown prosecutor, so it just came to my head that the timescales won't match up, because most of those will be in the Crown Court and they'll be going on too long compared to how long.
It depends. The claim that I was talking about was heard in last summer, and I think issued in 2018. So
we're pretty slow in the civil courts as well, I think.
Thank you.
I think a question, is there another question in the room before I have a look at the online? Oh, yes.
I sort of hesitate to raise this because it's a bit tricky, but I just wonder if you could say a bit more about the regulated mortgage contract stuff and the 2014 and 2016 changes, and what sort of impact I mean, clearly they've had very little impact in practice, but whether you agree with me that in fact it ought to have had more impact, and we ought to have seen more case law on the idea that most mortgages are regulated mortgage contracts now, and therefore the extended provisions of the Consumer Credit Act mean that there should be more representations made by borrowers to change the terms of those contracts.
I mean, my instinct on that is when I've been asked to consider, is this a regulated mortgage, is not actually a terribly straightforward question. I mean, you touched on it earlier. That is often not it's almost always the quirky cases where you're asked that question.
Right.
And actually, when you get to looking at the regulations, it's really quite complicated.
Right.
I suspect part of the problem is that those arguments do need to be had, but no one's brave enough to have them because the regulations are so complex, and you need the right case for it.
Yes.
But I agree with you. The impact of those provisions has been relatively minimal.
Yeah. Okay. Thank you.
I've only had it come up in 2 cases recently, and one was it was quite clearly not the regulations weren't applicable, and the other one, it dropped away before trial because the borrower was at one stage represented and then became unrepresented and decided not to pursue it. So I don't know how judges at trial have a feel for this, but anecdotally, having spoken to a judge once at a drinks event about it, is that they find this terrifying too.
Yeah.
Oh, I mean, I've raised it twice as a duty advisor to blank stares from both the judge and with respect to my opponents as well. And the case went in a different direction, so it wasn't, it didn't reach that trial stage where you'd get that deep dive into it. But your sense of it is you don't think it applies as much as perhaps some other people might think it applies. Or we just don't know.
Yeah, I mean, the only case I've had, it's been an odd case, so it's difficult to say. But I definitely think you're right that there are arguments that ought to be being made that aren't being made, perhaps because we're all so used to the old stuff.
People don't think of it automatically.
That actually there's a gap that people haven't started making those arguments. And often the problem, part of the problem is practically, if your client's in a difficult situation, they might not want to argue this point to trial. What they want to do is sort themselves out, and actually putting in a substantive defence of that sort is not what they want to do. What they want to do is get some time.
Yes, I guess the downside in running these arguments is very commonly you get stung, don't you? Because the costs get added to the charge, and then you as borrower have to seek an account to challenge those. So it's not, I suppose, like any defence, not a cost neutral thing, but there's a greater burden on you as a borrower there because you're not going to get an assessment automatically of the costs.
Yeah, the cost risk is not the same for each party.
I think the complexity point is a good one. I mean, I never try to trawl through this to try and work out how the regulations are changed and what apply to what, and suddenly going, oh, that's interesting. Those are not provisions I previously had on the forefront of my radar when I was dealing with residential mortgage work, because I think we're so used to things like the Section 36. You've got the usuals that everybody goes to, and actually I think it's not entirely clear quite how big the differences are between some of them, if that makes sense. Although they are different provisions and different powers in theory, there hasn't been that sort of concerted, I think, assessment of one against the other, and
whether the court ought to be applying a completely different approach.
Yes.
Well, they should be applying the Barnes approach.
Absolutely, but do they know that?
Well, no.
Possibly not.
No, sure. Can I say one more thing about, the summary judgment test?
Yeah.
Forgive me, Brooke, but you mentioned about, well, if a defence is in, then really that test is met. But forgive me, I think it's the other way round, because if a defence is not in, but somebody's arguing for more time, that's a different test, I think. And it's where a defence is available that the judge then should consider whether it meets that CPR test.
So I mean,
equivalent to summary judgment.
In that case in particular, what the court was looking at was, in circumstances where there isn't a defence, as you say, but the defendant articulates something that might amount to a defence, how far can the court go? And those of us that do these things regularly, often the court will, especially if the person is unrepresented, if they've articulated something that might well amount to a defence, give the opportunity for them to put in a proper defence. But I think the way it in reality is applied is that, you know, whether they've articulated that something that it might amount to a defence or there is a proper defence, they're still applying, is it genuinely disputed on grounds that appear to be substantial? Or are they having to do that sort of intellectual gap filling for a litigated person or someone who's not actually got a pleaded defence, which I think in practice, most judges do that.
I mean, it should be resisted because they don't have the material on which to judge that, and you know, sorry, that's thank you very much.
Were there any more questions in the room before I ambush my my colleagues with some questions on the screen? Evie, I think this might possibly be one for you. Was any guidance given on the following of the Ettridge protocol during COVID?
Oh wow, I don't know about that, but there were firstly there were internal rules from one of the regulatory bodies that deals with mortgage lenders, and there was, my recollection of this was basically
Well, there's a long-standing stay for all possession proceedings under Part 55.
but the lenders weren't enforcing, weren't bringing new claims, but about compliance with the specific requirements of Ettridge, there's nothing on that so far as I'm aware. I don't know of any cases on that. I can't see in principle why you ought not to have to comply still or be entitled to rely on it. I don't see why it's different to a solicitor taking instructions by Zoom in another sort of case. So maybe that's arguable by a lender. It seems quite weak to me. I don't really know where it would get you.
No, I mean, I'd have thought it would have been part of the bank's pretty standard protocols now, and so when that got transferred into the electronic arena of online mortgage meetings or whatever they were called, it would be carried across directly. But I have to say, I know there was some specific guidance around mortgage. I'm not aware of anything that was sort of Ettridge specific. But I suppose query whether we might see some cases coming out of perhaps actual undue influence. The presumption.
Maybe the arena for dispute will be on whether the solicitor could give written confirmation in circumstances where there were these barriers to, you know, compliance with the requirements. Just perhaps makes it harder for banks rather than. I suppose I'm wondering what guidance could have been given to help a bank in that situation.
I think one which may be possibly for Brooke, though generally opening it up to the entire panel. In terms of, I suppose it might be Evie actually, so I think you covered this. Sorry, the sort of adjourning proceedings or getting a delay in possession proceedings where there's a possibility of selling a property. A query has been raised of having seen cases where borrowers have sought to frustrate lenders' attempts to take possession by contracting to sell their property at the 11th hour with a very long period between exchange and completion, offered as sham purchasers. And a query about how that, in your experience, that can be countered by the lender at a hearing, and a query about whether a negative pledge provision within the legal charge might assist.
You're not going to be able to allege that a purchase is a sham in a first possession hearing, and the evidential burden for that would be quite high. I mean, it might be that as a lender, you're simply saying, well, we still need to make the possession order, but you know, you can factor in the purchase to the time for suspension. If you're the lender, you'd be resisting an adjournment, but you'd be saying that perhaps, you know, the time can be reflected if the evidence is there. I mean, you might be able to say, look, the evidence is pretty thin, but in reality, like I say, the shortness of the hearing means that substantive arguments are going to be really difficult.
Yes, I had a hearing recently where, in fact, a follow-up from that trial that I was talking about, where we got a warrant and then the borrowers applied to suspend it. And at the first hearing, they had incredibly thin, like one A4 page from less than from a estate agent saying it could be possibly sold for maybe this amount. So it wasn't even on the market. And they'd had so long and it was several years after the term had expired, and they got an adjournment. maybe a reflection on my advocacy ability. But I said to the judge, there's no evidence here of ability to sell within a reasonable period. And the judge said to me, well, I can take this. I don't need a witness statement. And I said, that is not a proper exercise of your jurisdiction. But it just reflects that courts really are disinclined from making orders for possession in these cases if they can avoid it. So I do think it is quite, you're really facing an uphill battle in that sort of scenario.
I suppose it might depend to some degree on when you get notice of the proposed transaction, because taking at face value the sham purchaser at the moment, I suppose if you get the witness statement 2 clear days before the hearing, and you do a quick search on this random company that you've never heard of that apparently is the purchaser, that might give you a bit of traction at the hearing. If it looks like it's an SPV that was incorporated or registered and doesn't even have any assets, as to how it's suddenly going to enter into a contract to purchase a valuable property. Particularly, there seems to be a connection between names on the registered officers and somewhere else. But I think I think that's the best you could probably do in the circumstances, isn't it? To try and see what you can find that might give the judge cause for saying, actually, I might adjourn this, but I want more on this transaction. I need to see a bit more to satisfy me that actually there is a reasonable prospect of this property actually being sold.
I suppose what I would imagine in that scenario is that you would get adjourned to a longer hearing, and that might be quite a short adjournment rather than, I can't imagine in a 15-minute hearing that a court is going to conclude that the potential sale is a sham.
Well, I suppose if there's a list and every single one of the properties in the list is going to be sold to the same purchaser with the contract at the same day on the same terms, you might the day you might get somewhere with that. But yes, and I think just finally there's a question whether the protocol applies to a mortgage which term has expired. I'm going to pick this one up on the grounds that I think I was the only person with access to resources when that question was being asked. From recollection, I don't recall anything in the protocol that says it does or doesn't apply with terms expired. My inclination would be it's always sensible to try and comply with it, not least in terms of things in the pre-action protocol which talk about things like possession proceedings being a last resort. And you shouldn't usually start proceedings unless all other reasonable attempts to resolve the situation have failed, and that things that you're asked to consider are whether it might be, for example, appropriate to consider extending the term of the mortgage. I've got something in the back of my mind about possibly in the context of one of the other powers about extending the term of the mortgage even where it's already expired. It may have been under the AJA where we were talking about that. So I would think it's probably always advisable, if in doubt, comply with the pre-action mortgage protocol, because it probably won't add much to the delay of actually dealing with it, but it could make a bit of a headache if you don't.
And it probably is helpful if you get to arguments about the AJA that you, as the lender, were saying, please, engage with this. If you're wanting to ask for a shorter time frame, it's only appropriate to adjourn or suspend for 4 weeks rather than 6 months, because you gave them so much time before you issued.
It's certainly something I've always thought about, and I know, Brooke, you talked about the importance of a witness statement from the borrower. I've always inclined to think your witness statement from the lender is a pretty sensible course of action shortly before your hearing. You can provide any updates. You can make sure that all of the documents are appended to the witness statement, which may have been lost when they're appended to the claim form. You can make sure that you've got your certificates. You can confirm what you've done to comply with the pre-action protocol. And you can, importantly, for example, if there has been a proposal that's been put forward by the borrower that you've rejected, explain in your witness statement exactly why you've rejected it. So if the borrower turns up at the hearing with the same proposal, you've already sort of got your oar in, as it were. I think we're probably drawing to the end of the session now. So unless there's any other burning questions, can I thank, firstly, all of our speakers today for their presentations. Secondly, all of you in the room and online for attending today's seminar. Thirdly, to remind you, this is the first in a series of our nuts and bolts proceedings that this sort that we're going to be running over the course of the autumn, and I think early into next year. I'm going to look to Brooke because this is her. She's the one responsible for all of this and knows the details far better than I do, but the details are on our website. And fourthly, just to finish with a plug for a conference that we have coming up on the 12th of October, Developments in Land Use Policy and Practice, which is a cross-discipline conference that we're running for the second time this year, which tries to draw together various things that may be of interest from different disciplines and practices that we work within that may be of interest to colleagues or yourselves in a different discipline. So without further ado, there are drinks and canapes for those in the room. For those online, I'm afraid we can't organise that virtually, but if I can just draw this to a close by saying thank you very much again for joining us this evening. We hope you found it helpful and informative, and wish you a very pleasant evening.